Hey everybody, again, Adam Tracy, cryptocurrency attorney. Want to talk to you today about Canada. I love Canada, great place, great companies, great technology. The Canadian Securities Commission followed the lead of the U.S. Securities and Exchange Commission this past Thursday and issued some guidance with respect to ICOs. And I found it instructive for two reasons. One, if you're operating in the U.S. or Canada, it's always useful to know the laws, at least to a tangential amount, of the other company or country rather, because there is some reciprocality to it, and also especially in the case of an ICO where it's sort of a global type event, you have a very strong possibility of obtaining Canadian investors and vice versa. Second, I found the decision to be a bit more instructive and a bit more detailed than what the US SEC came out, and I thought it may be instructive and informative with respect to where securities regulation may go as it relates to ICOs in the future. So there's three things that I think are important to take about. One, the Canadian Securities Commission found out, or called this, the quote-unquote regulatory sandbox, right? So they stated specifically that each ICO should be evaluated and analyzed in a vacuum, right? One by one, as opposed to lumping all these ICOs together. And I thought that was very important. In the Dow Token, the SEC cited a number of specific elements that were germane just to that token and applied those to current securities laws and said, well, this is most likely the issuance of a security, but it didn't actually give guidance to say, well, we're finding this based on just this specific token. So I think it was very important for the Canadian Securities Commission to say that and identify the fact that this is a standalone event each time an ICO goes, and they should be analyzed independently for the applicability of securities or commodities laws as it may be. Now, second, on the other hand, which I found to be a little bit disheartening, is the Canadian Securities Commission found that a token which entitles a holder to participate in the profits or success of that platform may in fact be a security. And I found that to be more expansive than what the US SEC did. And the US SEC did a very detailed sort of element by element analysis and compared the Dow token to ownership in like common stock, right? And those included rights to profits, voting rights, etc. And that's where it sort of ended, okay? The Canadian finding I found said with that simple word, success. What I believe they implied or want to imply is that if you are creating a utility token, for instance, or a coin in the truest definition of what a coin is, and the Canadian Securities Commission did a great job of differentiating a coin from a token. Well, what they said was, or at least what they implied, and I believe this is very important to especially early stage startup type ICOs, is when your ICO, whether even in the event where you're selling like utility token or a coin, if the proceeds of that ICO are used to build the platform, that may in fact be a security, even if that underlying token gives you no rights to profits or anything like that. So if you take the simple example of a video game platform that does an ICO and the coins being sold in that ICO entitle the holders to play the video game, right, for a cost, what I believe the Canadian Securities Commission is intimating is that may in fact be a offering of securities where the proceeds of the ICO are used to build that video game platform. So it's a bit expansive, it was a bit unclear, but it's something to consider because you see a lot of ICOs now where we're going to build the platform but we need to raise the money, and then you're going to be able to take your coins and use them on our platform, whether it's social media, video games, service, education, whatever the case may be. That would have a huge implication if those were deemed to be securities offerings, because I think it would shut off at this point at least a third of the number of ICOs that are going out these days. And finally, the thing that I've been harping on for a long time myself, third, is that the white paper in its the tangential form that people use when doing ICOs, the Canadian Securities Commission said that's probably not enough, right? And I've said this before. The white paper is great, but there's a salesy element to it, right? It hits sort of the high points, gives you sort of a brief overview, but it's not really a risk-based disclosure document, and I think it's important, especially it's required when there's an offering of securities, but even when you're decidedly outside the ambit of securities laws, I think it's important to put together some risk-based disclosure, which looks a lot like a private placement memorandum. You don't call it that, but you need that in there. You need that in there to, detail things such as use of funds, potential, risk of loss, potential implications of different laws, securities, commodities, money transmitter, you name it, general economic factors, things of that nature, which are required in the context of a private offering of securities. I think we need something similar to that, and I always advise my clients and prepare those for my clients that that's a necessary thing. And the SEC, or the Canadian Securities Commission rather, came out and definitely said that you need to provide something greater than the white paper that many people rely on alone when doing ICO. So that's my take. Yay Canada, and remember, visit me, TracyFirm, TracyFirm.com. Email me, at tracyfirm.com. Talk to you later.